Well, Eugene Ojogu, that director of admin in the NJC, to some extent, I should assume that that is self-explanatory, so it explains what happened thereafter. But now you heard that scenario, so if you will, you can link it with your earlier submissions about the entire scenario playing itself out.
Yes, the entire scenario is disappointing, to say the least. For the NJC to have refused the unsigned document, so to speak, it still passes. There is no excuse about that, even though this may be an academic discussion about the service and acceptance. It passes a wrong signal to the ordinary man there, who may become a litigant in future, and who may start looking at some of these little technicalities to refuse service. It is not for him. It is not for the NJC at that point to refuse service. In my view, what matters is for them to accept it and go to the court, appear before the court honorably, and tell the court that they will serve some documents which were not signed. As long as there is the stamp of the Federal High Court Abuja behind the processes, once there is stamped, once those documents are stamped, it shows that it has passed through the registry. When an unsigned document goes to no effect, and that is before the law court, not at the point of service. So having said that, we let us address the very issue, even the very issues raised in the process of the imbroglio between the CJN and the PCA.
So what are the issues that get into that particular document now that wasn't dated?
The issues, since the matter is in court presently, we will be very circumspect in discussing the issues. However, we can take them from some angles that would evade appearing to be subjudice. Yes, in a holistic context. Now, the most important points raised in the processes is the issue of fair hearing. The point of fair hearing, the NJC set up a panel, or two panels as it were, one headed by Abdullahi and the other one headed by some other person, Outer. Now, the NJC more or less has become the accuser, so to speak, after receiving petitions. Having become the accuser, they set up this panel, received the report of the panel, and they prosecuted. Let us assume they are prosecuting the CJN and the PCA. They prosecuted, and they reached judgment. For goodness sake, we are talking about audi authorem partem. Here the other party, you shall not be a judge in your own cause. If you are the prosecutor, it becomes wrong for you to be a judge. And in any case, even where, let us assume, without considering that the processes are correct, that the procedure was correct in terms of fair hearing, there should be a provision for appeal. The PCA or the CJN himself should have a right to say, okay, I have seen your report, your decision, but I may wish to appeal. For the decision of the NJC to be subject to interpretation or appeal, so to speak, before a federal high court, it tells a lot about the decadence in the system. There should have been a provision to allow anybody dissatisfied with the report or the decision of the NJC to bring up to go on appeal, and an independent body would look at the satisfaction of whoever appeals.
Yeah, but you know, the different scenarios at different points where this matter comes to just always seem to take our attention out of maybe something that preceded the subsequent occurrence. Because, for instance, this was predicated on the fact that Justice I. Salami, president of CJ Court of Appeal, had sworn to, he says, according to the allegation that he did so actually to an affidavit claiming that the CJN, Justice Aloysius Katsinelo, had asked him to compromise a panel set up by the Court of Appeal, which was handling the governorship crisis in Sokoto State.
Yeah, let's not use the word compromise, so as we respect.
But that's the word they said.
No, let's avoid using the word compromise, so that we take an objective view. What we should look at is interference from the CJN.
The alleged interference.
The alleged interference. The question is, was there any interference? And if you say no, there was no interference, then why should the PCA protest? And if you say yes, that there was interference, you ask the question: was it proper for such an interference to have taken place? And if you say the interference was for public interest, the question is: ordinarily, should the CJN have interfered in the processes of an election tribunal.
No, but what about the fact that, I mean, when this allegation came up against both of them,
yes,
there were those who thought that the right thing to have been done was both of you just step aside, while some committees of panel look into all of
not only step aside, Chamberlain, the appropriate thing for them to have done was to have resigned their positions.
Oh. Well, that's
yes, I am standing here to say it. I stand here objectively to say that when these allegations came before the public domain, they ought to have resigned their positions.
Both of them.
Both of them should have resigned their positions and allowed the natural course of justice to take its place.
Well, this thing has dragged on.
Without going into the propriety or otherwise, or whether there was any such event or not, or whether it was correct to have occurred in the first place.
So, are you saying, in essence, that if I raise an objection, I think that there is some interference here.
Yes.
If I raise that objection, I should be prepared to resign?
No, that's not. It wasn't an objection. Let's look at it this way. The PCA accused the CJN of interfering in the decision of the Sokoto State Electoral Tribunal, Appeal Tribunal. The authority in charge of that tribunal actually is the PCA. That was never denied. Secondly, other petitions also arose from the Ekiti and Osun State tribunals against the PCA. When those allegations arose, those ones ordinarily shouldn't lead to them to resign. But once they have brought it out to the public domain, the CJN granting press interviews, making press releases against the PCA, making press interviews against the CJN, and the CJN in return through his through officers also granting interviews.
Is it normal?
It is not normal. That is where we say that both of them, having done that, should have stepped aside.
And every time we try to talk about this, this is not the first time, we always have this feeling. Even some people send mails and comments. They say it looks like it's a difficult thing even for lawyers to comment on, because sometimes the truth is somehow hidden. They say that because, first, someone has made an allegation. There's an affidavit which before anyone could even receive that, it was in the press to start with. And there was this pressure on the PCA to withdraw that said affidavit, which he did. And now we're going back again to the courts, which ordinarily, or in the first place, he was asked not to go to. So what exactly do you think in an ideal situation should have happened? Should we have allowed him go ahead with that